right, very good. So, what we're going to talk about tonight is I've titled it Access Denied, the Power of Attorney Problem No One Talks About. And this, it's a little bit of a public service announcement that's really important to me because I've just run into scenarios working with clients where they thought they were prepared because they had their mom's power of attorney, but financial institutions, for reasons we'll get into, it just wasn't enough. So we'll certainly get into all this, but just to get a little more into my background at a high level, I've been in the financial services industry since the mid 90s. Started out as an independent advisor with what is now Ameriprise Financial Advisors. And I was there about 12 years, transitioned to a bank net worth or wealth management department and spent a number of years there, and then transitioned over to Vanguard. I was with Vanguard for about 10 years through COVID. And I would imagine, like most of us, COVID in many ways had me reevaluate where I was and what I was doing, and started doing a lot more research, wanted to get out of the corporate world back on my own, and just really understood what was important to me at that point. And I had some great relationships with my grandparents who lived into their mid to late 90s. My mom's dad was just shy of 100 when he passed. So both personally and professionally, I've seen the aging process, and this is what I want to do. I want to help family caregivers and families in caregiving situations. So that's a little bit about me. So what we're going to explore today is the idea of a power of attorney, what they are, the different types. We will get into what makes a power of attorney effective versus ineffective. We'll go over a couple of real life examples and talk about government benefits and what they require for you to be able to, help your loved ones out using those benefits. And then we'll get into, steps you can take and start getting ahead of some of these roadblocks and set yourself up for greater success. So what is a power of attorney? It's a legal document that basically just allows you or your loved one to name someone that they trust to act on their behalf. And just a couple of aspects of a power of attorney. When you're acting as a power of attorney, typically you're referred to as the agent or attorney in fact. As we'll get into, there are power of attorneys that cover financial, medical, certainly legal aspects. But it's all about allowing you, the agent, to have the ability to make decisions for those that you're caring for. Some power of attorneys are effective immediately once they're signed and notarized. Others may require a specific event to occur before you have the ability to step in and take action. Other aspects of power of attorneys that are important, the scope. So what does the language in the power of attorney allow you to do? Is it just medical? Is it financial? And if financial, what does that allow you to do? Does it allow you to make investment decisions and actually make investment changes? Does it just allow you to call and get information? So what you put in, certainly with a lawyer's help, as far as what the power of attorney allows you to do is really important. We touched on the timing of the power and when that kicks in. So again, it could be immediate or based on a future event. And scope also touches on limits of the authority granted, and we'll get into that. As long as the person who created the power of attorney, not the lawyer, but you or your loved one, you can revoke power of attorneys at any time as long as you're competent to do so. So power of attorneys are really, obviously in the name, powerful, and they're very beneficial. And if you haven't gotten any in place, either for your loved ones that you're caring for, or even for yourselves, we'll get more into that on the taking action side, but they need to be in place. So the general types of power of attorneys, general, which is effective immediately, they're broad powers, and they typically cover financial and legal matters. They, though, end at the time the person becomes incapacitated. So let's say your mother created with a lawyer a general power of attorney, listed you as agent, and over the years she is fighting a cognitive disease and is no longer able to make decisions. Well, the general power of attorney then becomes null and void based on that type of incapacitation. A durable power of attorney has a lot of similarities to a general, but the key aspect and the differentiator is the durable reference, meaning that it stays in place after the person becomes incompetent or has some of those challenges. A springing power of attorney is an example of the power of attorney that relies on a future event to occur before you have the ability to step in and assist. And those future events can be very specific. It could be, when my mother becomes incapacitated, then I have the ability to call on her financial accounts only, and get information and make investment decisions. So you can get very specific in a springing power of attorney, or be more broad, but still based on future events. So the more specific, it limits your ability to do and support your loved one, but maybe they're comfortable with that limitation because of fear or just concern over various aspects of giving up control. That's not uncommon. But the drawback of being very specific is that it has limitations. So with springing power of attorneys, you're trying to find that balance of allowing a future event to happen, but not be so limited that you're not ever going to be able to step in and help. The limited or special power of attorney, it could just be on even a more narrow scope, such as the only help I need from you is if I'm unable to sell my house for some reason on my own, that's what I want you to do. Step in and sell my house. And the medical power of attorney certainly deals with the healthcare side of things, being able to work with hospitals. Now, medical power of attorneys do not give you access to health insurance information. That would be more through, say, the durable power of attorney. So those are the different types that you'll be running across. And for setting yourself up in the best position if you are creating a power of attorney, again, either for your loved one that you are caring for, or if you're looking to put yourself in the best situation should something happen to you. Durable power of attorneys are probably the strongest consideration to lead with. Again, you'll want to talk with an attorney and find out a little more about your situation and talk through pros and cons of a lot of these from a legal aspect. But the durable power of attorney, from how I work with clients, seems to have the most value as far as setting yourself up to really be able to do and support your loved one in the best and most scenarios. If power of attorneys are not in place as your loved one ages, then one of the first hurdles you may be setting yourself up for is needing to hire a lawyer, go through a court process to gain guardianship. And that's a court process where it's up to the courts. You present your case and the courts decide if it's valid enough that they will give you the legal right to have guardianship over your loved one. So it's a much lengthier process, more hurdles to get over. So again, setting up, say, a durable power of attorney while you have more options is a strong consideration. Just providing a checklist for you, and it is in a downloadable form that Alex will have if you would like to access it at a future date. But in essence, whatever power of attorney you choose, and perhaps, it's a combination depending on the situation. It's one, you just want to make sure that one exists. The durable language, yes or no. So in other words, will it continue after incapacitation or not? Does it really give clear specific powers, or is it more broad? Is it signed and notarized? That's a huge part of it. Certainly, as you're in any profession long enough, you'll see situations that kind of make you scratch your head. And having a legal document created by a lawyer but never be signed or notarized happens a lot more than you think. Is it dated within 3 to 5 years? That's a time frame you may want to keep in mind for a couple of reasons. One, the caregiving scenario may change, the ability or willingness of the agent to be in that role may change, and legal terminology changes, the world changes. And so from a legal standpoint, oftentimes they are adding additional benefits and features, if you will, into these power of attorneys, which ensure that based on new technology, as an example, you have the ability to, again, set yourself up for success to support your loved one. Did you share this power of attorney with any institutions and providers? And believe me, we'll get a lot more into that. So just a checklist to help you maybe think things through a little more and see where you stand. So you have the power of attorney in place, the durable power of attorney. It's within the 3 to 5 year time frame. It's signed and dated, and you think you're all set. Not always. So why might a power of attorney be rejected or not accepted? We touched on maybe they're too old. A lot of firms or companies are a little more stringent, and they may require one that's within a few years. A company, a bank, or a financial institution, you may send them the power of attorney, but they read the language in it and it's too vague. Their legal department is saying, it's not specific enough for us to really feel confident it's going to allow you to do what you're wanting to do. It could be an out-of-state form that may not just be accepted. Missing signatures we touched on. Some other red flags. Some companies require originals and maybe all you have is a copy. Consequences when they're not accepted. It's going to delay access to accounts. Some accounts may be frozen if the internal compliance department of the institution that you sent it to feels something's off or isn't quite right. Then they're going to protect themselves, their organization, and say, no, we're going to freeze things right now until we review this further. And technically, things could always escalate for different reasons. So just a little more on that. And again, you'll be provided access to these slides in a PDF. So if you choose, you can have all of these to review when you have a little more time. So this is just a little more of a summary on that. Just to emphasize how important it is to have the power of attorney, meet all those requirements we touched on, and why we're going to want to start reaching out to the institutions to see what documents they need as well. That's to come very shortly, but just some real life examples. RBC, the Royal Bank of Canada, and this is just something an actual client of the bank put it on Reddit. You can search these and just see all kinds of scenarios. But the client of the bank, tried to use the power of attorney signed by both their parents so they could manage the joint account at the bank. Well, apparently the bank rejected the document because they felt the wording, they're phrasing it as the legislation, does not support a single power of attorney with multiple donors. So what the bank was saying is they wanted a power of attorney from each parent, even though the bank account was joint. Sounds like a small differentiator, but the bank felt very strongly that having a power of attorney that had two participants, if you will, was too confusing. So it caused delays, confusion. The bank required the client to go get a document for each of the parents. So that's just a real world example of where you think you're set up because you have the power of attorney, the lawyer drew it up, it was within, a couple of years, dated and signed, but the bank had other thoughts on that. Fidelity, a family presented a valid comprehensive power of attorney, again, drafted by attorneys. You don't certainly want to draw these up on your own with any expectation that it's going to be accepted. But they sent it to Fidelity to use on one of their parents' accounts. Well, Fidelity refused to honor the power of attorney and instead demanded that one of their own internal forms be completed, which the principal, i.e. the original owner of the account, couldn't sign anymore due to having Alzheimer's. So initially, the family couldn't manage the parents' investments or pay certain bills, and they had to take legal action to, again, go through that guardianship process, which, based on their situation, was the only option left. So the lesson here is many, many, many financial firms will not honor external power of attorneys and require their own institution-specific forms to be completed in advance. Thus, the topic of this entire presentation. So why have companies started to be less accepting of power of attorneys created by lawyers and created their own internal forms? Well, liability concerns. Certainly, financial institutions have a responsibility to protect their clients' assets and not end up being sued. If they accept a fraudulent or outdated or overly broad power of attorney, again, it could set that institution up for certain losses. Inconsistent language. Durable power of attorneys or any power of attorney is written by a lawyer in the state that you live, and each state has its own state requirements, verbiage, if you will, that they need in a power of attorney. And so the lawyer that you work with then has the ability to use their own specific language when they create the wills to meet the scope of what the power of attorney allows you to do, to meet the state requirements. So there's some flexibility on the language that could be used to meet all of these requirements. So envision, and I'll use Vanguard again just because I've worked there. Envision a company like Vanguard who has, I don't know how many clients, certainly quite a few, receiving a power of attorney from 50% of their clients coming from all 50 states, written by thousands of different lawyers. And each client has a specific need that they need to take care of for themselves or their loved ones. And so Vanguard has all these power of attorneys coming at them for one or two situations, and they're supposed to read through all these, understand the state statutes, and then align that with what you're trying to accomplish and align that with protecting Vanguard and its shareholders. It's a lot to cover. So you really can't blame them on saying, well, we still accept power of attorneys, of course, though we would really, really prefer you, and I'm using quotes on prefer, to use our internal forms, because we know the forms we've created are protecting us, but also, and as importantly, going to allow you to do the things that you're going to need to do. So these are the reasons companies have created their own internal forms to protect themselves. So now we're going to talk a little bit about government institutions and just give you some insight on what some of the hurdles are for you as agents to be able to support your loved ones. Now, Medicaid, again, are state programs funded largely by the federal government, but fall under state regulations and control. The majority of states, if they need any type of documentation, the majority of states are fine with a valid power of attorney to allow you to access financial records in order to support your loved ones. Again, they will look to see, is it outdated? They're aware certainly of the state it's coming from, and every state, again, has its own regulations. And so New York is a little more strict, and so they may have a few more hurdles that you would need to go through. But not every state seems to require even a power of attorney. But I would have one in place. Things are getting a little more compliance oriented, certainly. Medicare, different levels of access that you can shoot to get. Full access, which is going to give you broad decision-making capabilities. That requires form CMS 1696. And that can be completed online or over the phone with them. I'll be getting back to sending in the power of attorney with a letter of instruction. Online access it's just that. It's going to grant access for you to be able to log in under your loved one's account so you can receive some information, call in and ask basic questions. It's not going to allow you to make any changes. The online access I would need to be done while your loved one is competent and able to log in under their own username and password, and set you up for that capability. There is a form CMS 10106, which your loved one would provide you the ability to step in and get information on any personal health information that Medicare has on them. Now, sending in a power of attorney with a letter of instruction. If the simplest way to think of this is you want to fill out CMS 1696 and all the other forms we talked about, power of attorney with a letter of instruction is really the last resort when your loved one has a cognitive impairment and has not filled out any of these forms for you before. It's the quote last ditch effort, if you will, that you can send in the power of attorney with a letter of instruction, with a letter, medical records from the doctors verifying the incapacitation, and Medicare is going to review all of it and decide, if everything's in good order before they will give you that capability. Now, what CMS 1696 allows you to do is you're the primary contact on Medicare, basically once they approve you. Now, it's not to say your loved one would not be able to access their own accounts at that point. Of course they would, but you would suddenly be shifted to the primary contact for Medicare once that form has been completed and approved. So it's going to give you the same rights as the beneficiary. You can file appeals, communicate with Medicare, receive and make decisions on products, etc. What you can't do is they're not going to give you broad medical. It does not apply for Social Security. We'll get to that. They have their own process. It doesn't override a power of attorney or court-appointed guardian. So in other words, a power of attorney always is going to have its place, and it's always going to give you a leg to stand on if you don't get to some of these other forms, which is just going to make your life easier. So don't discount me saying a power of attorney has no place. It absolutely does, and it gives you a leg to stand on. But if these internal forms aren't completed, it's just a much bigger hurdle or hurdles to get through before you're going to be able to get some things done. VA benefits. What you can do now is you can, again, just get the power of attorney in place for non-VA matters. Your loved one can file a form 210845, which is going to give you as the agent the ability to have read-only access to their benefit information. They can complete a VA healthcare directive for medical decisions, which is again the VA's internal version of a medical power of attorney that your lawyer would draw up. If none of these forms are proactively completed, the VA will, at the time of incapacitation of your loved one, they will stop benefits. They will nominate someone if needed. You also have the ability to complete a form 214138, which is an interest in you being a fiduciary for your loved one's VA benefits. But that comes into play at incompetency. You can kind of set yourself up, get on their radar by completing that 4138 form, but it's not going to be reviewed and it's not going to be processed until the VA knows that your loved one is incapacitated. So that process, even in the best case scenario, may take some time. But once they approve that form and you as the fiduciary, then they will release all back benefits that they've held. But again, it's not a fun process to have benefits withheld for any reason. So do what you can now. Fill out all the forms, have your loved ones fill out all the forms if they're able. Get all the rights and access you can now. Get yourself set up for the time of incapacitation, and that's just going to make this process a lot smoother and happen more quickly for you and reduce the amount of time that benefits are withheld. Social Security has its own process. You would be applying to be what's called a representative payee. And Social Security is a little more liberal in that anyone could really apply. It could be your loved one's neighbor, it could be a family member. Social Security will accept applications, if you will, by calling that 800 number. Your loved one, again, can set you up as an advanced designation. They have the ability to give Social Security 3 names. It might be a little more, but we'll say 3 names of potential future representative payees. Under the advanced designation, no one is approved by Social Security. It's just on their radar that when something happens, then you'll be considered. The form that would be completed in order for you to advance, if you will, through the Social Security interview process and their background checks, etc., is SSA 11. Social Security is really careful about vetting people before they are approved as representative payee. Social Security does not accept power of attorneys. It's all their internal forms. Your loved one can go to their My Social Security account to set up the advanced designations, again, or they can call in. What a representative payee can do, they can manage and spend the benefits, pay for housing, food, healthcare, save unused benefits. There are a lot of annual reporting that you need to provide to Social Security. So you are highly monitored in this role, which is a good thing. So there's a strong compliance aspect to this, if you will. And the representative payee, you can be provided that right without your loved one being incapacitated, which is a little different than some of the other government agencies. So we've talked about how a power of attorney is important. In most cases, based on my experience, not being a lawyer at any level, durable power of attorneys seem to be the more prevalent I've run into when working with clients. But again, always talk with your lawyer and talk through your scenario and find out what's best for your situation. But make sure that for your loved ones, power of attorneys are valid. The agents are still willing to be in that role, that they're signed and dated, that the scope as to what these power of attorneys allow you to do is still going to work for your situation. Now, this is where the bump in the road comes into play. And this is where you're going to really need to think through and understand your loved one's financial situation. Where are their investment accounts? Credit cards? Do they have any car loans? Health insurance? Do they have any company benefits? Any and all accounts that you can think of that you would ever possibly need to reach out to and help make decisions, gain access to support your loved one. I'd write them all down and then start reaching out to those companies and asking questions about what internal forms, if any, they require to give you access and allow you to do what you need to do. And then submit the internal paperwork that they tell you they need. If they need notarized, you'll do all of that. And then secure records of who you talked with, where you are in the form process. Did you receive them yet? Did you send them back? Have they been accepted? All of that. And we'll get into more of this for those that stick around for the actual workshop part of it. I'm just trying to give you a high level aspect of the importance of power of attorney, some of the roadblocks, and about government agencies that you'll be working with. So what to expect as you're going through this process. It can take time. I'll use my parents as an example. I'm fortunate they're both in their mid-80s and are at home living a good life at the moment. But we've always been ahead of a lot of these because, of course, what I do as a financial advisor, but also my dad has just always kind of been interested in these aspects of financial planning. So we always had a lot of things in place. But it wasn't until last year that I was like, you know what, we still need to do this part of it. So I sat down with them and we listed all their companies, made sure I was still aware of all of them, all their accounts, credit cards, etc. And with them in the room, I made phone calls to each company. I had them in the room. It was beneficial because if there was any security, they were able to pass that and the company then could talk to me. So again, it's best to do these while everyone's able to work together. If not, then you just need to work through what their requirements are. But even best case scenario, it took probably about a month and a half to 2 months just to make the phone calls, receive the paperwork, complete the paperwork. If notarized, get them notarized. If they needed the originals, mail them back, all of that, and then follow up if we didn't get confirmation that they were in good order. So a little bit of a time-consuming process, but that's normal. But I promise you that if you don't address some of these issues on the front end and you wait until the crisis occurs, it's going to eliminate a lot of options. You're going to be really stressed out because you need access to the account yesterday. You need money, whatever the issue is, you're going to have to wait in many cases, and it's just going to make everything harder. So by acting now on these issues, it's going to help you reduce stress during those emergencies. It's going to eliminate a lot of confusion, protecting your own time. Because if you wait till a crisis, you're dealing with the doctor's appointments, the medical side of things, and then also you're having to get on a phone and call a financial institution and be on hold, maybe for 40 minutes. It's just not anything you're going to want to deal with. We're aware of this now. I'm providing you, I provided to Alex an Excel spreadsheet. Hopefully most of you are comfortable opening up the Excel. But again, we'll go through this during the actual workshop aspect if you want to stick around. But I've created a number of detailed information as far as what you want to ask and the information you need to get from the company that you call. Again, there's a column for the date you called the company, the date they sent you the paperwork, the date paperwork received by you, the date you had the form signed and notarized, the date you sent forms back. All of this is there in this spreadsheet as an attempt to really help you get organized on working through this process. And I am going to also provide Alex some additional questions that aren't in the spreadsheet that might be beneficial for you as well when you start making these calls. So if you don't have a power of attorney for yourself, or if your loved ones that you're caring for don't have them, or perhaps they're outdated outside of that 3 to 5 year time frame, or if the person they provided the ability to act on their behalf or the agent does not want to do it anymore or is not able to do it anymore, for whatever reason that document might need updated, it's always good to review and, if needed, get a new one in place. There are tools out there such as State Guru that helps you find lawyers in your state that can help you with these documents. Estate Guru is a tool that I have available for folks. They do provide free power of attorneys, HIPAA forms, durable power of attorneys, healthcare power of attorneys. If that's of interest for you, you can send me an email and I can provide access to that. Now, those free documents are very state specific. They need to be, they're written by lawyers in the states for which you reside. So they do certainly meet all the state requirements. They, though, may not be as specific or broad or meet your specific needs based on your individual situations. So I am one to always say, talk to a lawyer because they should be the ones asking you questions to fully understand what your needs are. So I would never suggest taking a template document over the benefit of an actual lawyer who will be asking more specific questions. That said, there are scenarios, there are financial limitations, et cetera, that this type of tool may be helpful for you. Again, the tracker I'm providing you and the series of questions. I've also sent Alex an email with a lot more information on the government, Social Security, and a little more about their process and forms, Medicaid, Medicare, the VA. So there's a lot more information available for you in the downloads that I sent Alex, if that's of interest for you. And I'm always here to talk more one-on-one if you would find value in that. So just a little bit more about me. I best serve the actual family caregivers, adult children who are in the situation that they can plan ahead for their aging parents, seniors who are healthy and looking to, again, prepare for themselves. And there's two sides of this coin, obviously, those that are going to need the help and you as the one that will be providing the care. It's always best to make sure everyone's on the same page. And a lot of families have a hard time with that. And I have the knowledge and the ability to work through those family challenges, to open communication and support in those areas if beneficial. Professionals balancing work and caregiving. 70% of caregivers now are women, working women, who are raising their own families, working, and trying to care for their loved one. It's certainly not a great position to be in, and so absolutely, I can help you in that situation. If you are if your loved one passed and you're working through settling estates and transitioning assets, etc. How I serve, I can get really into the nuts and bolts and do really in-depth financial planning, look at estate planning, retirement planning, how all these things tie together, give investment recommendations, help review insurance policies, give you guidance on if you're trying to buy a long-term care policy or interpret it. I'm not a lawyer, so when I say interpret it, I'm not giving legal advice, but I can help you understand the benefits and features and what it covers, etc. Now, what separates me from advisors, and then this will be it as far as me, I do not collect assets under management. So many advisors require certain investment levels before they'll work with you and help you. They'll require you to transfer assets to them in order to help you. I do not require that. I do not sell any products. I get paid for my time. So I'm what's considered a flat fee only advisor. No commissions, product sales, or assets under management. So I'm able to work with you based on your needs, not your income, or again, or assets. So I've really thought through caregiving scenarios and have done my best to offer services based on the situation you may find yourself. So while it's at the bottom, the Family Care Navigators Alliance, it's a membership I've created for family caregivers and even seniors that are able to still do a lot of this on their own, to be able to access some financial planning tools I've put in there, which will help you to do some budgeting on your own, consolidate account information, a lot of great features. Now, these tools are tools that I use when working with clients. So it allows you to do a lot of things. Weekly group coaching on aspects of caregiving. Certainly, I educate on the financial side, but also other content or questions that are appropriate for caregivers. And again, the supportive community that you're finding in Jubilee's Facebook community. But that's kind of where you can start, where folks can start if they like doing things on their own. If it advances beyond that and you have a more specific question or two, where you only want an hour of my time, you send me an insurance policy, Scott, can you take a quick look at this? I've got a couple questions. I'm just not understanding it. Yes, absolutely. Happy to help you in that scenario. Project-based, that would be working on a couple of aspects. Maybe your mom needs to be transitioned into a skilled living facility, and she's got a long-term care policy, but you haven't looked at it in 15 years. And so you're wanting to review the costs of your mom moving in, selling her house to help pay for it if needed, and the long-term care policy to just kind of make sure that over her lifetime, she's going to be taken care of. So that would be more project-based. The subscription approach is, you don't have time to do, quote, give me a lot of information on the front end, give me a couple of weeks to look at things. You just know you're going to have a lot of questions over the course of the year, and you want to have access to me, be able to send me documents, ask me questions, and have me be there for you as things evolve over time. So that's kind of I call that a monthly subscription approach. I do ask for an annual commitment to that, but pay as we go along. So that's that. Briefly, I am offering all members of Jubilee TV a discount on access to the Family Care Navigators Alliance, the membership I've created, all the tools, the weekly group coaching, community support, again, the resources to help you manage the financial, legal aspects of things, should you choose to have all those features and benefits. That's it. That's an honor to be here with you tonight. I really thank you for the opportunity to hopefully give you some insights on power of attorneys, some of the hurdles, and how to kind of get ahead of a lot of this.